So the first motion that we have is, well, they're not in any particular order, but I've tried to put them in order that I think makes sense. And the first motion that I am going to deal with is the motion filed by the state, essentially for a gag order on the defense. And with regard to all of these motions, I've read the motions, I've read the responses. If a response was filed, I have read any replies that got filed. So we don't need to take up court time rehashing what's in the motions. They're all well pled. If you have something that you want to add that was not in your written submissions, I'll listen to that. But with regard to the state's motion, which they didn't title for a gag order, but what it essentially is there anything further from the state that you would like the court to consider?
Adrian Love, Your Honor. For the state, Judge, we will rest on the authority that we have presented to the court and point out to the court that since the time of this filing, other instances similar to in nature to the ones that we pointed out to the court have occurred, and we would just simply ask the court to afford the relief requested in the state's motion.
All right, thank you. And anybody from the defense who needs to add anything to what's been filed in writing?
Good morning, Your Honor.
Good morning.
Doug Weinstein for Diamante Kendrick. We will stand on our response. The only other thing I'd like to add is to point the court to the case of WXIA TV v. State 303 Georgia 428, which discusses the presumptive unconstitutionality and issues with gag orders as prior restraint. That case is with respect to the news media, but there is some analogous language in that, and I'd just like to point the court to that. Thank you.
All right, thank you. All right, with regard to this motion, you know, I know that there were some things in it that suggested that certain of the defense lawyers might be running afoul of bar rules, and if they choose to take action that might put them in that kind of a situation, that's kind of up to them. And if there is a complaint filed, then they will have to deal with it. But I think that in regard to the propriety of doing that in this case at this time, I'm going to deny the state's motion. Obviously, if facts change and the state or the defense at any future time believes that it would be appropriate to consider this issue again, please raise it again. But at this point in time, we are going to move forward without instituting any kind of a restrictive order for speaking with the press in the case. With regard to the media, I'm just going to remind any of the media actors that are recording this case that the Rule 22s, they're in effect in Rule 22 period, only permits recording when the judge is on the bench, not during any recesses and not during any bench conferences. So let's make sure that we abide by that from here on out. I was having to reference some prior live stream that was in some of the motions that were filed and some of the responses, and notice that there were definitely times, at least in what I was seeing, that proceedings were being recorded when court was not in session, and Rule 22 does not allow that. So let's make sure that we stay within the bounds of Rule 22. All right. So the next motion that I would like for us to consider is Mr. Williams' motion, and I'm just calling him by who filed it. I know that everybody has joined in on everybody else's motions, but to essentially revisit Judge Krause's factual findings in her recusal order. Mr. Steele, is there anything you want to add to what's in the written filing?
Yes.
Go ahead.
Good morning, Your Honor.
Good morning.
Good morning, everyone. Your Honor, may I just step back for 1 second? Good morning, Madam Court Reporter. I am Brian, B-R-I-A-N, Steele, S-T-E-E-L. And along with the Honorable Keith Adams, represent Mr. Williams. Your Honor, what the Honorable Judge Krause found in her result, we don't take offense to, or we agree with, actually, but when she made some comments which were that this ex parte meeting might have been, I'm not looking at her order, might have been okay if it was done in open court. I strongly, and Mr. Adams, Honorable Mr. Adams, strongly disagree with. And the reasons are in the joint affidavit of Mr. Adams and myself, dated July 8th, 2024. And what happened here is you have a witness, Mr. Copeland. He was sworn on June 7th of 2024, and he invoked a privilege. To my understanding, Your Honor, he did not have a privilege to invoke. The state, and we didn't have notice of it at the time, but the state ordered, or maybe we did have notice. I didn't have the motion, but I had the order, I believe. The state asked the Honorable Recusal Court for an use immunity. So nothing that Mr. Copeland can use could be then turned around and prosecuted. So the way I understand the law is that protected anything that Mr. Copeland said. It was like an umbrella over him, so that anybody, federal courts, they could not use this testimony, but he could still be prosecuted. Somehow, according to the transcript, which is the ex parte hearing transcript, June 10th, 2024, there's the recused judge, Miss Love, Miss Bumpkus, B-U-M-P-U-S.
All right, and let me interrupt you for just a second. I've read the entirety of that ex parte transcript, so I'm familiar with what happened in that.
So my position is nothing there was good. Everything was wrong. And I believe, as stated in the affidavit and the motion, that there was intimidation put upon the witness to change his statement. He made it very clear, send me back to the DeKalb County Jail. I'm not testifying. I have a case for the court. And based upon what you just said, if I could just get that case,
Okay.
and I'll be right back.
All right, while Mr. Steele's looking for that particular case, just a heads up to everybody else that's going to be arguing case law. If they want to present a case, try to go ahead now and be getting that at your fingertips, okay? Is this a case that's not cited in your?
Yes.
Okay.
May I approach?
Thank you. Thanks.
So, Your Honor, I just provide to this honorable court and prosecution in one copy to the Honorable Douglas Weinstein of Archer, A-R-C-H-E-R versus Maryland. It is 859A, as in at least a 2D 210 2004 case. And starting on page 6 of 22, Your Honor, of the copy I've given the parties, on the right-hand side, right in the center, the Maryland court explains that here Bailey had been convicted, sentenced, and the time for filing an application for leave to appeal his guilty plea had expired. Thus, he had no Fifth Amendment privilege to refuse to testify. Contempt proceedings were therefore an appropriate response to Bailey's refusal to testify. So it's the same situation, except he pled guilty. Mr. Copeland was never charged. He's called an unindicted co-conspirator. It's announced by the state. On page 10 of 22, the appellate court in our sister state goes through what happened with the judge. Now, this is not ex parte. This is in open court. So this gets to what you asked about Judge Krause's findings. And what the judge said on page 10 of 22 on the left-hand side in the center, first full paragraph, we find that the trial judge's efforts to persuade the witness to testify went too far. If Bailey persisted in his refusal to testify, Judge Previs, P-R-E-V-A-S, had the option of either initiating direct contempt proceedings or constructive contempt proceedings. The authority to initiate contempt proceedings, however, is not a license to intimidate a witness into testifying. The purpose of the contempt power is to provide a means for a judge to uphold the dignity and integrity of the judicial process.